Good afternoon and welcome to the second day of the Africa Construction Law Conference West Africa session. Today we're talking about dispute avoidance and disputes. My name is James Doe. I'm a partner of Herbert Smith Freehills in London, and I'm also an advisory board member of the Africa Construction Law Initiative. So we have two sessions for you today. The first session concerns claims management and dispute avoidance, and that will be chaired by me. And then afterwards, there'll be a short break, and then we'll have the second session, which concerns dispute resolution and enforcement, and that will be chaired by Francis Yvonne Iguea. So first and foremost, we now have our keynote speaker to start us off. That's Ms. Diamana Diawara. Diamana is the Africa Director at the ICC International Court of Arbitration in Paris. Previously, she headed up one of the Africa section groups at the ICC, and she's worked for the ICC for over 9 years. Diamana, thank you very much for joining us today. Over to you.
Thank you. Thank you very much, James, and good afternoon, everyone. I am delighted to be with you today and to have the opportunity to address you on behalf of the ICC. And I would like to start by thanking, in particular, Go Martins for the amazing work he has done with this Africa Construction Law Week and the organizers of this week of events. I would also like to take a moment to praise this wonderful initiative that the Africa Construction Law is, and comes, I think, at a very important moment and as a very important stone in addition to the work that we, I think, collectively ought to do in order to reinforce the presence of African practitioners in the dispute resolution arena, and more specifically, the one occurring on the African soil. Now, I would like to set the scene for, and I'm happy to do that, for this afternoon's modules, which will be dedicated to construction disputes and transactions, as James has just mentioned, in West Africa. And to do that, I'd like to share some of my experience as a member of ICC and until very recently a member of a team, a leader of one of the team at the ICC court dealing with those disputes, and more specifically the West African disputes. And I would like to do that by giving you some insight into what my experience has been during that time, and the manner in which the ICC court assists parties in disputes involved in West African construction projects. As many of you know, the ICC court has over 100 years of experience under its belt, and in administering disputes all over the world. And the ICC International Court of Arbitration is often referred to as the preferred institution for the resolution of international commercial disputes. We have heard many of the speakers preceding me in this Africa Construction Law Week referring to public ICC statistics, and I would like to recall one of them that I think is really speaking to the importance of the topics that were addressed and are being addressed during this Africa Construction Law Week, and that is the portion of construction and engineering disputes in ICC arbitration in general. And that, if you look at a time span from 2016 to 2020, construction and engineering has consistently ranked as the first economic sector involved and represented in ICC disputes. And I think that says something about, the importance of that sector in not only ICC, but ICC as I would say, a barometer for disputes around the world, given its importance and its place. I think it says something about construction in general and construction disputes in general in the practice of disputes lawyers and arbitrators in general. I think what I just told you now for ICC statistics generally also is reflected for ICC statistics in West Africa in particular. Again, construction and engineering, if you look more in details into our statistics, are clearly the first economic sector appearing in the disputes that happen on West African soils over the past few years. Now, to understand a bit better what those West African construction disputes are at ICC and how the ICC has been, I would say, contributing to the good resolution of these disputes, I would like to mention the fact that when ICC is called upon to administer West African construction disputes, in most of it does so in very, very big projects. Big, when I say big, I mean in amount, in dispute at stake within the arbitrations, which is a reflection of the value, the financial value of the projects resulted into such disputes in the West African region. And just to name a few of those projects where ICC has seen a very high number of West African construction disputes, I would say the renovation or creation of container terminal in West Africa, West African maritime ports are one of those sectors where many construction disputes have been filed with ICC. I would also mention the rehabilitation of major West African railroad routes, or and there, for example, one public dispute that, or at least it was made public dispute that ICC had and is still dealing with, is one of the railroad projects, the Boucle du Niger. So that belt that goes through Niger, Benin, Ivory Coast, among other countries, which has triggered a very important and dispute with an important value, financial value at stake, and where ICC has had the opportunity to administer the dispute. And another sector that I think often comes back in those West African construction dispute at ICC is the creation of domestic infrastructure such as roads, bridges, or even for some big African cities, markets construction. ICC, thanks to not only its long-lasting experience, but also the wealth of the quality of the lawyers within the Secretariat of the Court and the arbitration practitioners sitting at the ICC Court, has successfully accompanied parties involved in disputes relating to these complex projects that I was naming earlier, by ensuring at all times that the integrity of the arbitral process is preserved, and that the arbitral proceedings result in the rendering of an award which will be enforceable at law. That guiding principle is inscribed in the Article 42 of the ICC rules, and that general rule, which obviously applies to all ICC disputes, finds a particular resonance, I would say, in our West African cases, construction cases, and I'll come to that in more details now. And to do that, I'd like to look a bit closer into those West African disputes and talk to you about the issues that arise out of those disputes, procedurally speaking, and that ICC will help smooth out in order to make the resolution of the dispute in those construction projects a success. Now, by nature, construction and engineering disputes, in our experience, are complex disputes, and that's how we categorize them. Because of that, a number of procedural issues will naturally arise in those cases that you will not necessarily find in a distribution dispute or an IP dispute. And these complex issues that will arise, procedurally speaking, would be multi-party issues. So traditionally, you will have a higher number of participants in a construction project than in a classic, let's say, sales agreement. And in those multi-party contracts, necessarily you end up with multi-party disputes, and multi-party disputes usually will come with a more complex resolution of the dispute. That is the case for the constitution of the tribunal. That is the case for the identity of the parties themselves. who am I introducing my case against? Am I going against the owner, against the engineer? Am I bringing to the table a subcontractor? These are questions that are extremely important, not only in African disputes, but I would say generally in ICC construction disputes. And it raises a number of points then, which is, for example, these are typically the cases where you will see after the arbitration has been set in motion, the joinder of an additional party, a subcontractor, for example. Or you will see a request for consolidation of parallel proceedings concerning the same project, overall the same project, but different sections of that project. And the ICC court will be called upon to decide whether or not the consolidation of these two separate disputes into one makes sense and is possible under the ICC rules. Another example of procedural issues that the ICC court might be called upon to smooth out will be, for example, like I said, constitution of the tribunal in facing a multi-party situation. If one of those parties decide not to participate, then the ICC court will appoint the entire tribunal. I will not dwell longer on that. I see that my time is running out a bit quickly, but I would like to, I'm stressing those issues because they do have a resonance when we talk about West African dispute, and that is the reason of that is the following. The particularity, as you know, of those West African economies is that they are state-driven economies, and that the fact that the state or state entities are generally the owners or the main actor in some of those projects, construction projects, will have an impact on the procedural behavior when the time of the dispute comes, and that impact is by, in our experience, due to not only the nature of the state and the heaviness of the state. So, for example, you will have longer delays requested in order to answer to a request for arbitration introduced against the state than you would with any other type of party. And that is something that we do see in particular in Africa, generally in West Africa as well. You will see also a higher number of cases in which the position taken will be not to participate in the constitution of the tribunal. Although I have to say that over the past few years, we have seen a great improvement from African state parties involved in ICC arbitration in this regard. They are making a huge effort because a good work has been done in making the states understand that not sitting at the table of resolution of the dispute is not making it go away, and that's not gonna. It's actually, foregoing a chance of making their voice heard. And that's really important that all of the actors sit at the table when the time of the arbitration comes. So these are some of the issues that we will encounter as an institution facing a West African state sitting at the table of a construction dispute. And of course, our rules provide an array of tools to resolve those, to smooth out this process and make sure that the case can go on despite those difficulties. But I wanted to leave the audience with this idea, which is that that particularity is something that you find in those West African cases, and that you don't, or African cases generally, and that is not necessarily something that we see in our caseload, generally speaking, worldwide. The last point I wanted to address today for you, before I give the floor to my colleagues, is with respect to the role of the ICC as an institution in improving, I would say, and reinforcing the market of arbitration practitioners in Africa, in West Africa. And over the past few years, the ICC, with its which is priding itself with the role of an institution being at the forefront of change in arbitration generally, has really taken this issue at the heart of its commitments and is making important changes. And that's reflected in the fact that in 2018, the president of ICC Court, Alexis Moore, who is stepping down next June, has done an incredible work of including more African practitioners within the ICC Court. And for West Africa, for example, we do now have 6 West African court members sitting at ICC for Cameroon, Senegal, Togo, Benin, Ivory Coast, and I'm missing one, which I will send probably in the chat to the audience. We have also done an important work in ensuring that whenever we could fix, whenever we were called upon to fix the seat of an arbitration in a case involving African parties, and it made sense to fix it on African soil, we would do that whenever we had the assurance that the local rules of arbitration, the laws of arbitration, were safe for the parties. And we did it so, for example, in the Ohada region recently in Burkina Faso. We did it also in Benin, because we know that the regime in place in terms of the legal regime with respect to arbitration is one that is safe enough to be confident that an arbitral award will be well received by the jurisdictions locally. The last important point in that role of ICC in really changing, shaping the market in West Africa is, of course, the efforts being made not only to nominate more African arbitrators, but more importantly, to really contribute to the emergence of a generation of African practitioners of arbitration. And that we do through capacity building initiatives, through, of course, through conferences, I apologize. But we also do that by simply engaging on a daily basis with the local actors and understanding what their needs are and accompanying them, be it in universities, be it in with local courts, the judiciary, in improving the arbitration market generally, and making sure that both at council and arbitrators level, African practitioners take a bigger part in this arena. I thank you for your attention, and I wish you a very, very, very pleasant session with our colleagues today. Thank you so much.
Thank you, Diamana. That's great to hear, actually, that the ICC is taking Africa disputes so seriously, and obviously having you on board to guide parties through and recognising some of the difficulties that can arise in particular on West African projects and construction disputes is great to hear. So certainly from a practitioner's point of view and a client's perspective, that's really reassuring to hear and great to hear, actually. So just to recap, welcome to the Claims and Management and Dispute Avoidance module. As I've just said a moment ago, my name is James Doe. I'm a partner at Herbert Smith Freehills in London. I also have the honour of being a member of the advisory board to African Construction Law. A little bit about my background. I'm a specialist in construction and engineering disputes and have been for the entirety of my career. That's over 20 years. Most of my cases are arbitration involving large major projects around the world, including in the Middle East, Asia and Africa. And I'm delighted to introduce you to our panel of speakers today. We have Maud Lebois, Uzo Ozo and Sena Jabedama. Our first speaker will be Uzo, and Uzo is a senior counsel at Chevron in Nigeria. Uzo is a commercial lawyer and supply chain specialist with over 14 years experience in the energy sector, both in Nigeria and in the Mid-Africa region. And she's led negotiations and the management of over $3 billion worth of multi-jurisdictional oil and gas projects. So today Uzo is discussing some of the common issues arising from construction claims in West Africa, and in particular from her particular perspective as an energy sector in-house counsel. So over to you, Uzo.
Thank you, James. Thank you. So good morning and good afternoon, everyone. Now, construction claims in the energy sector in West Africa and, of course, across the world can be analyzed from varying perspectives. They can be analyzed from the perspective of the company that has a need and authorizes another party to undertake the work, or from the perspective of the contractor, who is the entity that has the skill and expertise to undertake the work and who indeed has been authorized to perform the work by company. So over the next few minutes, I will be sharing with you some of the issues and trends that result in construction disputes or construction claims in West Africa from the perspective of an in-house company representative. Next slide, Louise, please. So construction in the energy sector involves very complex and high-risk operations, which then makes it imperative for the parties involved to be governed by very clear and defined contract terms that delimit the roles and responsibilities of the parties, as well as apportions risk to the party that is best able to manage the risk. So construction activities are typically undertaken as part of an integrated project scope, and that integrated project could take the form of engineering, procurement, and construction projects, which we typically refer to as EPC projects, or you could have EPC plus installation or EPC plus management. Now, this integrated project scope is typically adopted to manage the number of interfaces that the company would have to deal with, and also to make administration of projects generally simpler. But of course, with an integrated project scope comes a very significant capital expenditure outlay. Now, over the last few years, about 6 to 7 years, with the movements in crude oil prices, as well as the impacts, from COVID, we have seen across the world significant capex cuts. Now, these significant capex cuts have also impacted Africa, and the cuts in Africa have been really significant. With the cuts, we've seen fewer projects and much lower construction spend. However, available data shows that although we have fewer projects and we have lower construction spend, the contract claims on these construction scopes continue to rise. And so there's a fundamental point then that needs to be thought about, and that is, what is the source, or what could the potential source of these claims be? And how can we more proactively manage these sources such that we mitigate the claims from arising? Next slide, please. So we have pre-contract award sources of claims, and these sources are sources that arise before a contract is awarded and executed. So a fundamental reason for claims, in this phase is an improperly framed contracting strategy. So in the bid to minimize interfaces and to make administration of projects simpler, in developing your contracting strategy, you may find that you do not pay attention to the capabilities and capacity of the contractors you have in your bid pool. So you may have seasoned construction contractors in your bid pool, but those contractors may have zero or almost no engineering experience or procurement experience. And so if you adopt an EPC contract method, for example, what you might be faced with is a situation where the contractor completely struggles to either undertake the engineering or procurement scopes directly or to even subcontract them. So the contractor struggles, and that results in delays to the actual construction work and ultimately delays the entire delivery of the project. And so what you find in such situations is that the contractor then seeks creative ways to make claims on the engineering and the procurement scope that maybe shouldn't have been awarded to them in the first place, given their lack of experience in that specific scope. Now, another source of claims, at the pre-contract award phase is a poor linkage between the legal terms in the contract and the scope of work or the contract compensation. An example I would give here is if you're drafting a contract for a brownfield construction scope of work where certain components of the work are undefined, right, and which would require the contractor to actually commence work to be able to then determine the full extent of the work. If for such scopes you decide to adopt a lump sum compensation basis for the entire scope, including the undefined scope, then you may have inadvertently just created an opportunity for a claim. Because very likely, when the contractor shows up at site and commences the work, the contractor would most likely say that they did not anticipate the extent of work or the magnitude of work that they have to undertake. And this can arise even in situations where you're almost certain that the contractor actually priced in the maximum possible risk into its bid. Unfortunately, with lump sum contracts, you're not able to get into the granular detail of pricing And so you really may not know what risk the contractor has priced in. But the contractor will take the position that it has not priced in the amount of work that it sees while on site. And so you may end up making payments for a scope that you may not have had to pay for if you adopted a different compensation basis. So the last point I will talk about here is underbidding by contractors. In recent years, this has probably become the most common source of contract claims. Now, local content rules, as well as JV partner or government stakeholder requirements may mandate that you award contracts to the lowest bidder. And so, what has become a practice is that some contractors will put in bids that certainly cannot get the work done. The moment you award the contract and execute such a contract, the contractor immediately begins to posture for claims. And so from the start of the relationship, you have a very difficult relationship. But there are tips, to mitigating this underbidding problem. Next slide, please. So, sorry, the slides aren't showing up very well, but here we have the post-contract award sources of claims. And these are claims or sources of claims that revolve around administration of the contract, as well as the relationship of the parties. So the first point I would highlight here is adopting a company versus contractor approach to contract management rather than a collaborative approach to contract management. So given how complex construction operations can be, certain levels of flexibility are required. And so where the contractor has real-time issues that it needs to address, and an example that comes to mind would be clashes, which are very common with construction work in the energy sector. So where the contractor faces clashes or other construction-related real-time issues, and you do not work collaboratively with the contractor as it seeks to address these issues, and you wait till the end of the day when it delivers the project, you highlight areas requiring rework, you may not be able to challenge a claim that is put forward, especially when the contractor can demonstrate that if you highlighted those issues as it went along the way, it would have been able to fix those issues rather than reworking all that has been done at the end of the day. So a collaborative approach is really fundamental to successful delivery of projects. Now, another source of claims, in this phase is invalidating the terms of your contract by conduct. And it's important to highlight here that collaborating or taking a collaborative approach with your contractor, is not a pass to then invalidate the terms of your contract. You can collaborate effectively while still ensuring compliance with the terms of your contract. And there are some simple ways by which, a company representative may invalidate the terms of its contract. And an example will be just deviating from the formal communication channels established in the contract and adopting informal communication approaches such as verbal communications. You can also invalidate the terms of your contract by instructing the contractor to undertake work in a company preferred manner rather than in the manner set out in the contract. And then you also can invalidate the terms of the contract by authorizing a contractor to undertake work in a manner that is clearly misaligned with the terms of the contract. So when you do all of these things, you basically set a precedent. And what happens is in the future, if you seek to ensure that the contractor complies with the terms of the contractor will cite the precedent that you have set. And then it becomes really difficult for you to walk back from the precedent you've set, and you'll be faced with the claims where you insist. So the last point I will talk about here is scope changes. This also is a very common source of construction claims in the energy sector. Now, generally, given how complex the work is, and just given the nature of the operations, construction contracts in the energy sector will set out clear rules around how to go about scope changes. However, scope changes can disrupt ongoing work. And many times, the company and contractor may not even be aligned on the full extent of the scope change, to ongoing work. You may also have disagreements around the schedule impact or the compensation impact. And so the more scope changes you implement, the more likely you're going to be faced with claims. And it is always very gray and very difficult to reject claims that are associated with scope changes. Next slide, please. So impacts of claims. Here, a fundamental point to mention is that there's no winner, or no winner basically emerges from a dispute situation. And so where, for example, you've obtained a significant arbitral award in your favor, but then, you've strained an ongoing relationship that is critical to execution of an ongoing project, or you've missed significant milestones and you have project costs that are way above what you anticipated as a result of claims, then even when you get an award in your favor, you may not really have won. And so claims are extremely disruptive, and should be avoided or mitigated where possible. So some of the points highlighted here are, first, claims can have or can serve as a significant source of distraction. So the same personnel that oversee the performance of work by the contractor are the same individuals that will be required to put together your claims defense position. And so where these individuals are spending their time trying to put together your defense position, they may find that, or you may find, that there are delays on the ongoing scope. And so that may be a source of a future claim, which, if not managed very carefully, can result in its own issues. Then, like I mentioned before, claims can really strain relationships. And so if you have ongoing work and your relationship has really broken down with your contractor, then executing that project may be extremely difficult, and you may have significant project milestones that you may miss as a result of the strained relationship. Now, there are cost implications with claims. So you may have significant legal costs depending on how far the dispute goes, but you may also have significant costs that arise from delay to the ongoing work. You may have a cascading effect, because if you have other ancillary scopes or associated scopes that need to be undertaken, the delays to the current scope can impact all the other scopes and result in significant cost escalation. And so it can be really expensive to deal with claims. And then lastly, schedule slippages. Of course, if there are delays on the ongoing work, you may find that you have a schedule slippage, and there'll be a requirement to extend the project schedule. Next slide, please. So finally, construction claims and you. So here I have a few tips, that we really need to think about, as in-house company representatives. So if you're an in-house company representative in this journey of mitigating contract claims, on construction projects, it is critical that we think about some of these tips. The first I would mention here is that a contract is not an insurance policy. So it's not a document that you flash when a dispute arises. It is a document or set of documents that should really govern the relationship of the parties. It should govern the actions that are taken throughout execution of the work, right? And then, another fundamental point that I'd like to mention here is that you may not be able to avoid a claim because you really cannot control the action of your counterparty, even when such actions are frivolous. However, you may be able to mitigate the likelihood of occurrence of a justifiable claim. And you can do that by developing a contracting strategy that appropriately apportions risk, amongst the parties. The party that is best able to handle risk should be assigned that risk. Then you also, can use your contracting strategy to mitigate the underbidding problem I mentioned. And you can do that by simply obtaining your government partner or stakeholders approval to insert a baseline price or prices, as the case might be, in your contracting strategy, which then provides an opportunity where contractors that underbid or bid below that base price will be disqualified automatically. So the key here is getting your stakeholders alignment, but that's a critical way to mitigate the underbidding problem. Then you also, can mitigate the occurrence of justifiable claims by drafting clear and consistent contracts that are devoid of conflicts between the legal terms and the compensation or the scope of work. And then active management and administration of the contracts is really critical. Then another point I'd like to highlight here is that what you do really matters. And it goes back to the point I had made earlier, which is your actions or course of actions can invalidate the terms of the contract. You may set a precedent by the actions that you take, and the contractor will cite the precedent, and that can really be a major source of claims. So being mindful of what we do as company representatives is critical, and ensuring that the actions of the parties stay guided by the terms of the contract. And then lastly, your helpful recommendation may be cited as interference or an instruction. So before you make a recommendation, it is critical that you really stop and test that recommendation. And in fact, we test the recommendation, before making such a recommendation. And so to sum this all up, just given the impacts of claims, it is imperative, that as a company representative, you adopt a life cycle approach in mitigating and managing contract claims by proactively identifying potential sources of claims, actively and effectively managing those sources so that you do not face full-blown claims, and where indeed claims arise, then you administer the contract by the terms of the contract such that you then mitigate, the occurrence of justifiable claims. Thank you very much.
Thank you, Uzo. Thank you very much. Excellent advice there, actually, about how to manage claims from an in-house perspective. I recognise a lot of the issues that you raised there. Absolutely fantastic. Just to remind everyone on the conference, attending the conference, that if you have any questions for Uzo or any other speakers today, please use the question app or the question function on the app, the GoToMeeting or GoToWebinar app. We'll be delighted to answer those questions in the Q&A session at the end. So now moving on to our next speaker, Senna Bedema. Senna is a chartered civil engineer and senior managing director at Ancura's construction disputes and advisory practice. Senna reviews and advises on underperforming capital projects, analyzes delays to projects, on ongoing projects as well as in disputes, and in disputes acts as a programming and delay expert. Senna has over 25 years experience with roles in the public and private sector, spanning every stage of the capital project lifecycle, from project startup through procurement and contract management to project controls and commercial disputes. He has delivered assignments across EMEA and given evidence as a delay expert in mediations, dispute boards, and testified in numerous arbitrations. So today, Senna is talking about delayed projects in sub-Saharan Africa, the usual suspects. Over to you, Senna.
Thank you very much, James. Move on to the next slide, please. So as James says, I'm going to be talking today about delayed projects in sub-Saharan Africa, and I'm going to be looking at the usual suspects. And by usual suspects, I mean that these causes of delay are delays that are causes that are typically found or are typically experienced in the region. We all know that things like scope changes, lack of access, lack of design information, even disruption related to COVID, the COVID pandemic caused delay. However, in this presentation, I want to focus on the key causes of delay that I find typical of the region in my assignments. So next slide, please. And next slide. So funding. We know that funding is the lifeblood of projects, and nowhere is this more so than in West Africa, where funding arrangements can be complicated. The obvious cause of delay to a project is a lack of funding. And you can see that there in a shortage of funding. Sometimes projects get started with partial funding and not the full funding for the whole project. And when the participants are unable to secure the full funding, the project stalls. Too many cooks. Yesterday we heard how the landscape is changing. PPP arrangements are becoming more commonplace in some countries. EPC contractors are coming to the table with their own funding backed by banks. Sometimes projects are donor funded. This makes for a complex web of agreements and contracts that are put in place to fund the project. And it only takes the withdrawal of one party or an issue with one party to stall the funding and delay the project. The complexity also means that the approval process for securing staged or additional funding can be lengthy or ridden with red tape, which again can cause delay to the project. Of course, the opportunity for corruption can mean people take their eye off the ball, and project funds can get diverted, which can also cause delay. One particular example I've listed there is where a government in Southwest Africa could not actually offer or issue a sovereign guarantee for a project. In that particular instance, there was a delay, but eventually the Mutual Investment Guarantee Agency provided the guarantee for an $85 million loan. And next slide, please. The wrong deal. Next slide, please. So the wrong deal in construction. We heard Uzo talk earlier about effectively the same issue about the wrong deal, and I'll explain. So she was talking about the contractor not being able to manage the actual deal they had signed. Well, this is the same situation, but perhaps from the other perspective. What we find in sub-Saharan Africa sometimes is typical of what we in the construction industry sometimes call the unintelligent client. So we got this term intelligent client, unintelligent client. The term intelligent client is referring to the maturity of a client organization. Maturity of a client organization means it's got the processes, it's got the systems, and it's got the people who are competent to manage infrastructure projects. Typically in other jurisdictions, you find that these intelligent client organizations are organizations that are set up for delivering projects over and over again. So typically, perhaps a railway board for a country would be an intelligent client, and a client who's just building a new headquarters would not be an intelligent client, or a client perhaps building a one-off factory for their ongoing operations may not be an intelligent client because their processes and systems are not geared up for it. Well, in sub-Saharan Africa, you sometimes find that the government departments enter into these contracts with private entities at a disadvantage because they don't perhaps understand technically the type of deal that they're making. They may not recognize the disadvantageous positions that they're entering into from a risk perspective, and normally would advise or would suggest that they take appropriate legal or expert advice. And equally, their procurement departments may not have reached the level of maturity, again, the process, the systems, the people to sign the deal. They end up signing the wrong deal, and what happens? The project stalls because they don't actually understand the deal that they're signing. The example I've listed there is one that I was involved in. The project was eventually cancelled. It's an iron ore project in Central Africa. The formal tender process took place in 2016 and got cancelled later on, about 2 years later on, or 2 years after that. Next slide, please. Forced marriages. So forced marriages is, again, something that is perhaps typical of the sub-Saharan region. And by forced marriages, I mean an engineering entity or a large multinational wants to bid for a project in the region. This multinational agency may be brought together with a local entity to deliver the contracts as one EPC contractor. This bringing together of these two entities may be driven by local content compliance. Izo mentioned something similar earlier, or otherwise, you would not have found these two entities getting into a contractual or a JV relationship together because they're incompatible as organizations. Their cultures are different, organizational cultures, I mean, technically, and the way they approach their technical solutions for the projects may be different, and socially they're different as well. And these incompatibilities can lead to delay and lead to delay of the projects. There was another example, a processing plant in West Africa. The local entity was a West African construction company, and the design and engineering was done by a Finnish company. And actually, that project failed in the sense that it was over budget and delayed. And the main reason for that was the cultural differences between the two organizations in trying to deliver that project. Next slide, please. So local content. Local content is an issue that's come up. It came up yesterday, came up again in Uzo's presentation earlier, and it will keep on coming up throughout all the presentations in this session, I expect. And the issue in terms of delay is that local content regulations are continually changing in sub-Saharan Africa. They are sometimes changing with each government that's coming into power. They change regularly by particular sector, if you like. Local content around various regions of the same country might actually change, and the pace of change is different in different countries. Quotas and compliance differ by country and sector. And again, the project stalls. And why does the project stall? It's because the multinationals who are coming in to deliver the project may not actually understand the local content regulations that they are going to be faced with. Sometimes they might sign the contract years before they actually start construction on site, and during that time, new local content regulations may have been enacted, and of course that can lead to problems from a delay and disruption perspective. In this example that I've listed at the bottom of this slide, local content quotas were particularly strict in Southeast Africa. This is actually in Mozambique, and an LNG plant suffered significant setbacks while trying to deal with the local content laws. Next slide, please. Inappropriate designs. In the transactional model yesterday, we heard that there are more infrastructure projects taking place in sub-Saharan Africa. I think we would all attest to that. We also heard about how these projects are more and more are being funded by PPP or EPC, PPP arrangements or EPC contractors. And in the process, energy, oil refinery, power stations, companies, the way they achieve this economy of scale is by providing a design, an off-the-shelf proprietary design that can be repeated over and over again wherever they happen to build, for instance, a power station or a process plant. So large companies like General Electric have standard components that they supply or they use on power stations that they construct. Sometimes the problem is the environment may not have been taken into account. A component that works well in Siberia, say, may not work well in sub-Saharan Africa, where it's humid and quite hot. And one particular example that I was involved in, it was a power station that was built, and it was built near the sea. And the different components were actually corroding or undergoing corrosion even before the project was finished. And so they actually went straight into defects correction on those components. Next slide, please. Customs clearance is a perennial favorite suspect. It comes up time and again. The movement of goods and people is crucial, and we heard that yesterday. It's crucial to construction generally, and even more so in Africa. And sometimes this can be hampered by customs clearance and immigration laws. Again, they're an area that's constantly changing, and again, sometimes with each changing government. And in some countries, the procedures for clearance are quirky and perhaps not intuitive to what one might expect, or what one might be used to. Say, if you're a multinational or contractor that is used to delivering projects, perhaps in the Middle East, might expect similar customs and immigration laws to apply in sub-Saharan Africa, but that might not be the case. So it's all about the due diligence around customs clearance, really, to avoid delays that are caused by that. Of course, customs clearance and immigration laws are susceptible to corruption. And really, when you look at how this manifests on the project, how does it impact the project? The answer is it impacts the project deeply and far and wide. Some of the issues that make this particularly, that make the impact particularly great in sub-Saharan Africa is some standard equipment turns out must be imported, because in another country where it may be a standard equipment, it has to be brought in. So everything, pretty much everything, comes through customs. Visas for skilled resources. I'll talk about skilled resources later, but there are typically more skilled resources needed for projects in sub-Saharan Africa, where due to perhaps the local population, the skill of the local population not being quite on the same level as some other countries, the contractor or multinational might find that they're bringing in more people due to the need for their skills. And of course, sorry, next slide, please. Poor infrastructure. Now, poor infrastructure is a key one. Typically in West Africa, most of our transport is via road, So effectively, we have one option for the movement of goods as well as people. And this can also affect projects. It can delay the delivery of resources, of resources and manpower. The Africa Development Bank, I saw a statistic published by the Africa Development Bank that says it creates an additional 85 kilometers between trading countries. The World Bank says 75% of trade delays are caused by poor infrastructure. And the infrastructure can manifest in different ways. It can be either through transport, it can be through power supply, intermittent power supply. For instance, when you're commissioning a process plant, cement plant, power plant, they all require sources of power, and they need a period of fault-free running, for instance. And the amount of times I've seen claims that relate to grid outages on projects in sub-Saharan Africa is significant. So I would say that intermittent power supply is a key cause of delay on projects like that. The capacity of the infrastructure to cope with the environment can also be a problem. In one cement plant in Nigeria, the cement plant was being built in an area where the access to it was by a bridge that got washed away in the floods, and so until that bridge was repaired, the project had to effectively go on hold, because there was no way to get the goods and the goods and people over to the site of the project. Even in the service industry, there's, typically in consulting or in doing deals with other organizations, the amount of times in the past where I've found myself being able to perhaps have just one meeting in traveling, because I've had to travel from Lagos Island to Yaba, for instance, or from Tema to Accra, does not leave much time in your day for anything else. So it can actually affect the day-to-day work that you do as a professional on construction and engineering infrastructure projects. Of course, we're on the cusp of a new dawn with video conferencing, which should alleviate some of the problems, especially as West Africa is ahead of the game, perhaps not on bandwidth, but ahead of the game in technology, because it's been forced to. But of course, the movement of goods and skilled resources to construction sites will still be an issue, and still be an issue that contractors have to recognize as a risk and price for accordingly. Next slide, please. Skilled resources. Now, skilled resources is one that I've mentioned before, and is one that can delay a project significantly. The issue mainly being is that the local population as a workforce may not be as skilled for the particular project, although that situation is continually improving. With one energy client that I've been involved with, their first project, the staff on their first, it was an energy client, building power stations. Their first project was all foreign resources. The next was a mix of foreign and local, and the third was predominantly staffed by the local population. So their situation is improving, but it's still an issue, particularly in the later stages of the project. So other linked causes along with this are, along with the lack of skilled resources and along with the standard of education, is you know, a consistent underinvestment in the region, and perhaps an unbalanced focus on production of raw materials by the country. Sometimes, or I think it's generally accepted in West Africa that we are now embarking on actually producing more products and entering more into the manufacturing into the manufacturing arena or sector. Typically in the past, we've been focused on producing raw materials, whether it's bauxite for aluminium or oil or gas that needs to be processed elsewhere. So typically the countries have had an unbalanced focus on raw materials, and all of this can lead to delay. Now, no presentation in this day and age is complete without a nod to the global pandemic, which has had an impact, and nowhere does it impact does it impact on the causes of delay than skilled resources. And typically in the UK or the Middle East, the claims around COVID-related issues have been about delay during lockdown, where they haven't been able to access the site, or reduced productivity from having to follow various welfare guidelines and regulations that the governments have felt that they needed to enforce to control the spread of the pandemic. But I have found it has manifested in a bit of a different way in sub-Saharan Africa, and that really is around the inability of skilled resources to either leave their countries of origin or being unable to enter the destination countries due to lockdown and various restrictions, and that has impacted projects, and it particularly impacts projects that are perhaps have a higher need for skilled resources later on, say during the commissioning of a power station or the commissioning of a metro system. So, so just quickly to sum up, the usual suspects that I have found affect the sub-Saharan region, or that are particularly relevant to the sub-Saharan region, are funding, governments entering into the wrong deal, the prevalence and the different local content requirements from country to country, customs clearance and immigration, inappropriate designs, that's designs that may have been engineered for elsewhere, forced marriages, poor infrastructure, and a lack of skilled resources. Thank you.
Thank you, Senna. I particularly agree with your position on forced marriages and cultural differences. As someone who's worked across the globe, often see international contractors having to, or engaging with local contractors or contractors from elsewhere, and that causing major problems with the cultural clashes between the two entities. Thank you very much, Senna, for your talk. So the final talk today is by Maud Lebois. Maud is a founding partner of Galliard, Bane Fatimi and Shelbaya, and prior to that she worked at Sherman and Sterling for 15 years. Maud has considerable expertise in construction arbitrations on African projects, and also acts and advises for construction clients, advising on contract and claims management. So today Maud is talking to us about whether the use of model contracts in the construction sector actually minimises disputes. Maud, over to you.
Thank you, James, and good afternoon, everyone. I'm delighted to be here. So we will spend the next 10 minutes addressing the question, would the use of model contract minimize the risk of dispute? I mean, this straightforward answer is probably yes, but we will see that it's not as easy as it seems, and some precautions should be taken. I found the question interesting in relation to West Africa because my experience is that in this region, the systematic use of model contract is not as generalized as it is in other regions in the world, for example, in the Middle East. And I will be happy to share your views, to have your views during the Q&A session on the use of model contract in the construction sector in West Africa. Now, if we look a big picture in terms of dispute in the construction sector, from my experience, approximately 60% of the dispute in the construction sector relate to performance of the contract. So performance means delay, variation of scopes, etc. It has nothing to do with the way the contract was drafted. The contract was not an issue. Now you have the remaining 40%, and in this 40%, most of the time the contract is an issue. You have missing or unclear contractual terms or poor drafting of the contract, and that's 40 remaining percent that you may have a chance to reduce the risk of dispute if you use model contract. But it requires some precautions when you use model contract, and I will make 4 practical consideration to that effect. I mean, first, when we use the term model contract to refer to any contract, it's true that what I've seen most of the time in companies, in my clients, is that they tend to use the same, I mean, the contract that have been previously signed by the companies as a model. And as you can imagine, there is a huge risk that if inappropriate clauses are included in this contract, they are actually repeated in a series of contracts. So you need to be very cautious when you use contracts that has been signed that has been entered into by the companies as model contract. It has to be reviewed by counsel specialized in construction sector. For instance, to give you a concrete example, one of my clients included in one contract, and it was actually repeated in several contracts, an arbitration clause which include that the entire arbitration process is to be resolved within 3 months. So 3 months after the constitution of the arbitral tribunal. As you can imagine, it was problematic because the average duration of an ICC proceeding is probably between 12 and 24 months. So 3 months was very short, and it was even more problematic that it was included in contract signed by the owner. I mean, my client was the owner, and as owner, you are most of the time respondent, so you have very few time to prepare your defense. As a contractor, you can prepare your claim and then decide when you file your arbitration. I mean, second practical consideration, when you use model contract, you need to pick the right model contract that fits the needs of your project, and that's not as easy as it seems. I mean, the most popular model contract are the FIDIC contract, and FIDIC stands for the Fédération Internationale des Ingénieurs Conseils, so in English, International Federation of Consulting Engineers, and they have a series of model contract. You also have other model contract like the NEC contract, the New Engineering Contract, or the ICE contract, the Institution of Civil Engineers contract. So you need to pick the right model contract, because if your model contract is too complex, it can actually increase the risk of disputes. Let me give you a practical example. In relation to the FIDIC contract, which are the most popular contract, as you know, we call that the rainbow suite of contracts because each contract is a color. I'm sure you're familiar with that. You have the red book, the yellow book, the silver book, and you will pick the color of your book on the basis of risk allocations. For instance, if you have an EPC contract, as user referred to, meaning an engineering, procurement, and design, engineering, procurement, and build contract, a turnkey contract, you will probably use the silver book. Now, once you have found the right color for the FIDIC form of contract, you still have to select the edition of contract because you have several editions. The most commonly used edition is the 1999 FIDIC contract, but you have a most recent edition, which is the 2017 edition. And actually, the newest edition is not replacing the old one. They coexist. You can pick either the 1999 or the 2017, and they are significantly different. The 2017 edition is much more detailed and prescriptive. To give you an idea, approximately 80 provisions in the 2017 edition of the FIDIC contract have require some notification by one of the parties, and some of this notification requirement has a time bar effect. So you may lose actually your right to file a claim as contractor if you do not file this notification within a certain period of time. So what it means is that if you do not have the internal resources to follow closely the performance of the contract, file the notification on time, you may actually increase the risk of dispute at the end of the day. A third practical consideration, is the amendment to the model contract. Usually, the parties want to amend the model contract, and then you run the risk to introduce inconsistencies and affect the balance of the contract. So when you start amending model contract, it's probably safer to have the final version of your contract reviewed entirely by a specialized counsel. I can give you an example, a practical example that I'm actually working on now. As we saw, you have some notification which has to be done with a certain time frame. Under the FIDIC contract, the contractor has to file the claim within 28 days. If it's not filed within 28 days, it's time barred, like the contractor can no longer file, can no longer claim. And my client decided that for the variation, for the modification that has been instructed by the owner, this time bar effect would not apply. So if the owner is at the origin is instructed this modification, the time bar will not apply. But if the contractor is the parties which initiated this variation modification, the time bar effect will apply. So they modified slightly the model contract to that effect. And actually now we are dealing with a major dispute and proceedings, because for each modification, for each variation, we need to determine which party was originally instructing the other on this specific variation. And it's actually difficult because the contractor say, oh, but during this meeting, the owner told me to change this and this. And the owner say, yeah, but you as contractor, you signed a change notice, etc. So it creates more dispute risk than if we had follow the model form of contract. Now, the fourth and last practical consideration is pay attention to the applicable law, because when using model contract, the parties often think that the contract is a standalone document, which is a document disconnected from any legal system, and it's actually not the case. As you know, the applicable law play a major role and can affect and prevail over the contract terms. You need also to keep in mind that most of the model contracts, certainly the NEC contract, model form contract, and to a certain extent the FIDIC contract, they are influenced originally by legal system from the common law countries, and certainly the English legal system. Now, if your applicable law is from a country of civil law tradition, you need to pay attention to certain clauses. some examples. The definition of gross negligence. You never find a definition of gross negligence in model form because it is very specific to a legal system, but it's key. So before choosing the applicable law to your contract, you need to have a legal advice on what is the extent of gross negligence under this legal system. For instance, under French law, it is admitted, or at least a certain case law accept that repetitive negligence behavior can amount to gross negligence. So it is important because it's quite often that you have repetitive negligent behavior in a contract. Other question of applicable law is certainly the revision of liquidated damages clause. On the French system and civil law system in general, the judge is actually, and the arbitrator is has the power to revise the amount of liquidated damages, can increase and can decrease the amount of liquidated damages, and that will depend whether the clause of liquidated damages include an amount which is, I mean, the standard, the criteria on the French law is the manifestly excessive. So if you contract this on the French law, you may have to include more wording on the reason why the liquidated damages amount, including a new contract, is not manifestly excessive to avoid this revision of the amount of liquidated damages by the judge or by the arbitrator. It is also the case of force majeure, which is well known. I mean, the force majeure regime is completely different under the civil law and the common law system, and actually the FIDIC model contract used to have force majeure clause, and now they have changed that and they have used the terms exceptional events clause. But the problem remains, like you need to define the regime of force majeure under the applicable law. So as we can see, the use of model contract in the construction sector is certainly a good tool, certainly a good starting point, but it can also be a double-edged sword. Thank you very much for your attention.
Thank you, Maud. Thank you very much indeed. I totally agree with everything you've said about model contracts. You've got to be careful. They're not a panacea, and particularly where people amend them without really understanding the full consequences of those amendments. We now have a little bit of time for Q&A. I think originally we'd scheduled a bit more time, but the talks we've had have been so interesting that it made sense to carry on with those talks. So I just wanted to probably open the floor to my fellow speakers and ask just a couple of questions and for everyone to chip in. The first question I wanted to talk about, both Uzo and Senna mentioned contracting strategy, and in particular Uzo mentioned underbidding, which is in my experience one of the most common causes of disputes. The pricing is wrong, the contractor's in a hole financially, and a claim is the only way out. I just want to start with Uzo. Underbidding, wrong contractor strategy, what tips, what advice would you give to some of your fellow in-house counsel or construction advisors who are concerned about that issue? I mean, what can be done, do you think?
Okay, thank you, James. So one of the points that I highlighted, during my presentation, which I would elaborate upon, is, the possibility of including a baseline price in your contracting strategy. So the goal really is to try to eliminate, the underbidding. And so one way that has worked actually is to insert a baseline price in your contracting strategy. Now you require the alignment or buy-in of your government partner or stakeholder to be able to insert that baseline price in your contracting strategy, because what it does effectively is, if the contractor bids below the baseline price, then they get disqualified. And so many times what you would have to do is to establish a credible baseline price. And for you to establish that credible baseline price, you may then have to refer to industry benchmarks, industry estimates about regarding executing that scope or work components. And so being able to establish a credible baseline price is critical to get the alignment and buy-in of your government partner. And when you do, and you set that baseline price, then effectively, parties that choose to underbid or bid below that baseline price would automatically be disqualified. So that is, one way in which you can actually solve the underbidding problem. Thank you.
So Uzo, I mean, what you're really saying is have a pretty good idea. If you're the owner, make sure you've got a pretty realistic idea about how much it's going to cost before you bid. That strikes me as leading on to another issue, which we can come on to in a moment, which is about training and experience of the project management personnel from the very start of the project, even before you've actually let the contract. Use people who've got a pretty good idea about what it's really going to cost, the problems, the challenges. Senna, did you want to add to that on the contracting strategy side? I mean, obviously there are lots of different models. Maud mentioned Red Book, Yellow Book, Silver Book. When you're thinking about FIDIC, do you want to go cost reimbursable or on the other extreme, turnkey? I mean, what considerations do you think parties should have before they dive into a contract, deciding which strategy to use?
Yeah, thanks, James. I think in terms of contracting strategy, not all clients will be in the position, in the fortunate position to have a complete understanding of their scope, so that they will be able to prepare a credible baseline price. Credible baseline price would also involve having a credible program. After all, time is money and tends to be the biggest contributor to the contract price, if you like. What I would suggest, in addition to what Uzo said, is if you are in that position where you don't actually understand your scope as much, then what you should do is understand the risks to the contract. So the risks that are associated with the contract, like for instance, you don't know, you should be able to price the level to which you don't understand the scope, and you should be able to price all the unknowns that you anticipate, like for instance, how long it would take to bring in some long lead item like a tanker or barge or something like that. If you're able to come up with a fairly detailed or comprehensive risk profile, you can actually allocate that risk within the contract. The other thing that that people should be aware of, or I say people that perhaps contracting organizations should be aware of, is we talk about FIDIC, we talk about ICE, we talk about all these standard forms of contracts, and I find that people's familiarity with these contracts differs from sector to sector. So FIDIC is typically, energy, international, power stations and the like. JCT is typically buildings. IC is typically infrastructure. NEC, you find a lot of transport organizations adopting that. So it's really knowing also the contracts that you're playing with, as Maud was saying, and using the contract that's applicable to your sector can also help, because there's familiarity on that, on how the contracts work.
Yeah, absolutely. I mean, Maud, you mentioned FIDIC, and we've all spoken about it or just mentioned it in this session in passing. do you think, I mean, do you think the clients that you've come across, parties you've come across, have thought very much about risk and how that is reflected in the contract? I mean, one thing that we haven't touched on a great deal is design risk, and obviously, you know, that's a big feature of the FIDIC forms, how design risk is allocated between the different books. And I don't know what your experience is, but sometimes you find people modifying red books to be more like yellow books, and yellow books making them look more like silver books. People shifting risks around in a way which the drafters of those contracts hadn't really anticipated. I mean, what would your advice be to clients about that? I mean, in terms of identifying risk and then reflecting that in the contract.
Yes, yes. One thing that I found is that for technical risk, like we have technical team most of the time with very careful studies, like hazard up studies with very detailed schedule. But for legal risk, we rarely do that. So indeed, with my client now, I set up a matrix of legal risk and trying to identify whether every single risk has been addressed properly in the contract, and that require from time to time to amend model contract because you have obviously specific risk to specific projects. But it's true that there is two way of dealing with it. Like legal risk are rarely as systematically analyzed as technical risks, and it should not be different. It should be addressed systematically as would an HAZOP study would do for technical risk. It's also important, I believe, to assess the modification to be included in model contract, and that's where counsel come into play to assist client. Because, for instance, the dispute resolution process of FIDIC, I don't know what and see nothing about that, but I found it very heavy. I mean, you have two stages in this resolution process. You first has a dispute adjudication board decision, and then this decision is not binding. You can have a notice of dissatisfaction and initiate an arbitration proceeding. So it's a very long process for dispute resolution, and that's the type of clause that you can easily modify.
Yeah, absolutely. I mean, different parts of the world have different views about things like dispute resolution boards and the and actually the practical benefit of those in certain jurisdictions. So I totally agree with that. Can we just move very quickly? We haven't got a lot of time, but I just wanted to touch on contract management. It comes up all the time, as it has in these presentations. Seems to me to be of critical importance. Uzo, in terms of how we can train project managers, lawyers, and people familiar with construction contracts, how can we go about training project managers and contract managers more about how to manage the contracts more effectively? Because it seems to be common through all three of your talks that contract management is a really important part of dispute avoidance.
Okay, so I'm a firm believer of doing, right? And so, you know, going through classroom training may be a good way of passing on learning, but on-the-job learning is actually one that provides, in my view, the greatest amount of experience. And that has been, you know, my experience as well. You know, I've gone through training, but there's never been as much learning as actually undertaking the work. And so, you know, my view would be that organizations just understanding how important these construction scopes are, and especially in the energy sector, where these construction scopes are really complex. They're very different from the basic services type contracts. And so, you know, the company would then need to be a little deliberate in how people get assigned to these different projects, you know, as they arise, so that they actually get on the job training. And, you know, it's interesting that, you know, when you talk about design, for example, and engineering, you know, even when you want to train someone or a project manager to be an expert in construction, it is critical that they also understand the risks that arise with engineering, because, you know, it's almost impossible to be completely clueless, I would say, about the engineering risks that arise, because many times where you have engineering issues, they will show up on the shop floor where the contractor is undertaking work. And so to be able to have contract representatives, or your company representatives, or project managers who are knowledgeable about how to manage this contracts in a way that will mitigate claims. My view would be on-the-job learning, get people to be part of these projects from the early phases so that they understand front-end loading and how that impacts actual construction work. And with that on-the-job learning, you will find that you then understand tricks that come up or issues that come up, and you can better catch the sources very early and mitigate the claims. So that would be my view.
Thanks, Suzu. I totally agree with you. That's sound advice. Listen, that brings us to the end of this part of today's session. I'd like to thank the speakers, Maud Lebois, Uzo Ozo, and Shauna Bededama, for their input. Thank you so much for taking the time to prepare your presentations and speak to us today. Please hang around for the next session, which starts in about 5 minutes, dispute resolution and enforcement. Thank you very much for attending, and good afternoon.
Good afternoon, everyone, and welcome to the second segment of the Africa Construction Law Week. It's been such a pleasure to be present and listening to the first part. It would be good for me to give you a short introduction on myself. I'm Frances Yvonne Igwe, and I head the Africa practice of Spencer West, and that covers multi-sector project matters, which is heavy on construction. And so it's a very sort of keen area to my practice, and one that I enjoy immensely. And so it's a privilege to be able to chair this session and to speak on this really vital aspect of matters. We had a really good session earlier, listening to really leading practitioners on points or leading sort of key issues to do with dispute avoidance and claims management. And it was very interesting listening to Senator Bidima's points that set out all the sort of issues that crop up in terms of funding, in terms of local content knowledge from multinationals, and also very keen to hear from Maud as well, who spoke on the fact that disputes account for about 60% of disputes really are related to performance, and about 40% are related to contracts. So inevitably, with all the sort of best laid plans, disputes do crop up, as you know, as practitioners in this sector. They are quite a huge issue in the construction industry. And so it would be very interesting to hear from our esteemed panel on dispute resolution methods and their experiences in West Africa. So without much further ado, I would like to introduce our wonderful panel. And I will start with Ms. Adiola Ogunbiade Adeyemi, who's a senior associate from Banwo and Igodalo, Lagos, Nigeria. Ms. Adiola is in the Disputes Resolution Practice Group, a top-tier commercial law firm in Nigeria. She regularly advises on contractual breaches from complex commercial transactions, enforcement of contractual rights, construction disputes, and expropriation of economic rights. She's been engaged in multi-jurisdictional litigation and complex international commercial arbitration disputes over the years. Involved in major arbitration proceedings in Nigeria, and was also part of the highly publicized Econet Wireless shareholders dispute, which birthed a series of arbitration proceedings in Nigeria and the ensuing challenging proceedings before the Nigerian courts. She's currently a member of the dispute resolution practice group, where, amongst other roles, regularly conducts arbitration hearings, domestic and cross-border arbitral proceedings. She's passionate about writing on a wide range of legal issues. Her articles are published in reputable law reviews and journals, and she's a director of the African Construction Law Initiative and an alumni of University of Toronto. So welcome, Adiola. I will then move on to an introduction of Ms. Nanya Owusu Ankoma-Saki. Nanya is a partner of Benzel Angel, Lexa and Ankoma in Accra, Ghana. And Nanya is part of a first-tier law firm in Accra. She regularly advises and represents clients in a range of high-value litigation and arbitration disputes, including construction disputes, and is particularly noted for her innovative approach to solving complex legal issues. She also sits as an arbitrator and is a board member of the Lagos Chamber of Commerce and International Arbitration Center. She's a counselor of the LCIA Africa Users Council and editor of the IBA Arbitration Committee newsletter, and is called to the bar in England and Wales, as well as that in Ghana. So welcome, Nanya. And finally, but not least, we will go to Mr. Tunde Fagokunlu, who's a senior partner at Aluko and Oyebode, Lagos, Nigeria. Tunde is a senior partner, head of the litigation arbitration practice. He specializes in commercial litigation and has litigated on an extensive range of issues, including the matters pertaining to oil and gas, maritime, intellectual property, telecommunications, taxation, finance and banking, receiverships and insolvency, and commercial law transactions. And he litigates both at trial and appellate levels. Tunde has represented various clients, including oil companies, telecommunication companies, and banks, both in litigation and arbitration proceedings. And he renders legal advice to a wide range of clients, local and international. He also represents Nigeria as well as foreign and multinational clients in arbitration in front of arbitral institutions such as the International Court of Arbitration of the ICC. So thank you all for taking the time to be on this session. It's a really exciting session for me, and I'm looking forward to a great panel discussion on the matters that we've set out. And so in understanding all the various issues that we've encountered pre-disputes, we are now looking in this session at disputes resolution, the different forms of dispute resolution available and popular in the West Africa region. And this is obviously going to include arbitration, mediation, and adjudication. And so I would start with Nanya. It would be good to hear from you, Nanya, on your thoughts and experiences on this topic.
In the construction industry, we have 5 major forms of dispute resolution. The first is litigation, secondly, arbitration. Then we have mediation, adjudication to a limited extent, and in rare instances, expert determination. Now, amongst these 5, the most popular are arbitration and litigation, and there's no wonder why. Both arbitration and litigation offer binding decisions and are enforceable. And therefore, a lot of construction projects have arbitration clauses, or sometimes allow for parties to go to court where there are disputes. The less popular forms of dispute resolution are mediation and adjudication. Now, usually in my experience within the construction industry, mediation is usually employed as a first step in a multi-tier dispute resolution mechanism. So usually parties would require that when there is a dispute at the first instance, parties engage in mediation for about 14 days, for example, to see if they can settle this dispute on their own. If they are not able to, then they can either go for arbitration or go for court proceedings. There are even instances where the mediation is in two phases. The first is where the parties themselves have attempts at mediation, and then they involve perhaps designated officials, senior officials in each company, come together to try and help the parties resolve the dispute before they go to arbitration and mediation. Now, currently, that is how mediation is being deployed in the industry, but I fully expect that mediation is going to gain a more prominent role in dispute resolution in the years to come. This is so because last year, for example, the civil procedure rules of the High Court incorporated mediation as an important dispute resolution mechanism and as part and parcel of the court process. So now a court, if you bring a case to court, the court of its own accord can refer the matter to mediation if it feels that the parties would benefit from mediation. Now, the problem with that, of course, is that mediation would only give you a settlement. It's non-binding. The parties have to agree to a settlement. The good thing is that if the parties are able to agree to a settlement and they come back to court, then the court then adopts that settlement as consent judgment. And it being a consent judgment, it can be enforced like any other judgment of the court. So I expect that with this change, mediation is going to take a much more prominent role in the resolution of disputes. More so because in our Alternative Dispute Resolution Act, we actually have a statutory regime for mediation, which also allows parties to have a mediated settlement and then have the court adopt it as its judgment. So I expect that in the coming years, mediation is going to gain more prominence. Adjudication, unfortunately, is very rare in Ghana. It is not usually used as a form of dispute resolution mechanism. How adjudication has been used, in my experience, is at the early stages of a dispute, just like in mediation, where adjudication is provided as a step in the process, where parties go for adjudication, and when they are unable to reach a decision, or where there's a decision that is given that they are unhappy about, they move on to arbitration. And we normally see adjudication feature in FIDIC contracts. Personally, I've only been involved in one adjudication where in that particular instance as well, it was used as a first step towards the resolution of the dispute. And what it provided, what the contract provided, was that when the decision in the adjudication is reached, even though it is not binding forever, and a party can choose to move ahead to arbitration or litigation within the period where a further step is taken to take the matter onto arbitration or litigation, that decision becomes binding, which helps the projects to move forward in the interim. So that's how I have seen the different forms of dispute resolution being deployed. In terms of independent expert determination, I have only seen that once, and that was where it was a minor issue, but of quite some significance to the parties to the contract, and therefore they agreed that a designated expert will take a decision if a dispute arises on that, and that would be binding. Apart from that, I haven't come across any other instances in Ghana where expert determination has been deployed, although in other jurisdictions such as England, expert determination is becoming an integral part of dispute resolution.
Thank you, Nanya. That's really interesting to hear from the Ghana perspective. And yes, it is clear that mediation and adjudication really aren't necessarily a core aspect of the dispute resolution process, although it's looking very positive in terms of where things are going with mediation. It would be good to hear from Adiola on the Nigerian perspective, please, because I think that we might find some synergy in there.
Yes, of course. So in Nigeria, typically, arbitration is very popular when it comes to resolution of construction contracts. I mean, in my experience, I've hardly seen litigation being used as a means of resolving construction disputes, especially when you have very large and very complex contracts. What the parties typically do is just, in the construction contract to already insert an arbitration clause. So in Nigeria, arbitration is fairly common. But again, what you usually have, just like in Ghana, is sometimes you have either a two-tiered system or a three-tiered system, depending on the form of contract. So if the contract is based on JCT, for instance, what you find is you have amicable settlement first, or mediation. So you have either amicable settlement or mediation, and then if that doesn't work, you then go to arbitration. But if the contract is based on FIDIC, what you typically have is a tiered step, which is first you have amicable settlements. If amicable settlements doesn't work, then you have adjudication, and if that doesn't work, then you go to arbitration. Fairly, I've been involved in a lot of contracts, that has adjudication provisions. I guess because in some of those cases, the contractors were international contractors, and FIDIC is quite popular for international contracts. And again, in some of those cases, they had to do with, construction of a cement plant, which is very complex and has a lot of design implications. So I guess maybe that's, you have, of course, for one of the FIDIC standard contracts, you have the yellow book, which sort of helps which is very useful when the contractor is responsible for design of the project. So I have seen a lot of construction contracts, having adjudication provision, despite the fact that we don't have, as of today in Nigeria, we don't have a statutory regime for adjudication, unlike the way we have it for arbitration. But I guess the party just decide and say to themselves that they want to get the benefits of adjudication, which is why they decide to retain adjudication in their contract. For mediation, even though typically, like I said, if it's JCT, you have either amicable settlement and mediation, and then arbitration, or if it's FIDIC, you have amicable settlement, and then adjudication, and then arbitration. What I've typically seen with mediation is that half of the time, even in the JCT contracts where you have mediation or where you have amicable settlement, which is some sort of mediation in its own way, maybe some sort of informal mediation, is that half of the time the respondents half of the time would not engage with that process. So even when the claimant, kicks off the mediation process, you find the respondent who has been asked to maybe pay some monies, or maybe it's a defective issue or whatever the case may be, not engaging with the mediation process. So what I've seen in my experience is the mediation process then becomes activated when the claimant then goes to arbitration, and then the arbitration process has, started and gotten to some point, you know, that's when the parties then in some way go back to mediation. So what I'm trying to say is, even though you have mediation in most of these contracts, you find out that in practice, the respondent clearly engages with the mediation process, which then gives the claimant the opportunity to move to the next stage. But the moment the claimant moves to the next stage, then you see the respondent coming back to the table, and in some cases, they're then able to have a mediation process, either during the arbitration itself, before an award is given, or sometimes after the award has been given, then you find the parties again coming together to mediate the award as it were, maybe have a compromise as it were. So in summary, arbitration is really popular, even though parties have the option of going to litigation, but in my experience, what I've seen is arbitration is really popular. Then if it's a FIDIC based contracts, you have adjudication. If it's JCT, you won't say adjudication.
Thank you, Ajola. That's really helpful, and it again echoes the same position, whereby across the continent we see arbitration as the sort of main preferred model of dispute resolution. But it would be interesting to know Tunde's perspective on this, especially in relation to specific aspects or specific issues that crop up in litigation, and whether arbitration or the other forms of ADR are really the best way forward. Tunde, look forward to hearing your thoughts on that.
Thanks, Francis. And I think Adeola and Nani are quite right to underscore the importance, particularly of arbitration in the construction sector. And again, like Adeola and Nani pointed out, adjudication is rare, but it's beginning to grow. Litigation hardly gets mentioned. And I think the reason for that is because when contracting, parties typically tend to put in arbitration clauses or your tiered clauses, which typically excludes litigation. In my experience, I've seen significant role that litigation plays in construction contracts. And of course, the reason why that's the case is because of the nature of litigation. One, litigation offers you a very quick way of getting remedy, interim relief. Secondly, litigation offers the prospect of summary judgment, where the claims are liquidated and hardly contestable. And it's in relation to those two features of litigation that I think negotiators of construction contracts need to pay some attention when they are designing the dispute resolution clause. I've seen, for instance, an example where a construction contract had a clause that allows, that says that if the contractor tenders an invoice and the employer does not dispute that invoice within a period of time, typically 14 days, then the invoice is deemed approved. Now, if a dispute arises, if the employer fails to pay an invoice that has become deemed under that clause, and the contractor goes to court to try to get summary judgment, because after all, the contract says that the invoice is deemed approved. If the contract has an arbitration clause, then there is a prospect that the employer would say, you are in the wrong forum, you need to go to arbitration, notwithstanding that the invoices are deemed approved and therefore provide legitimate basis for a liquidated money claim and therefore summary judgment. I have actually experienced that before, where I applied for summary judgment in court in relation to deemed approved invoices, and the employer raised the arbitration clause. Now, as we all know, looking at the rules of most arbitral institutions, there's very little scope for summary judgment. And so, notwithstanding that invoices are deemed approved, if it goes to arbitration, you have to, hear the claimant, hear the respondent, go through a process that might last up to 12 months, 24 months probably. And so that's one advantage that litigation provides above arbitration. And I think negotiators of these of construction contracts perhaps want to segregate some features of the contract where disputes could arise, where they want to make it clear that you could go to litigation if this was a kind of factual scenario you are presented with. Another scenario that I typically see in practice is when you need to get some urgent interim relief. And I've actually seen clauses in contracts, not necessarily within the construction space, but in other sectors, where, particularly in the financing sector, where the parties specifically make it possible for you to go to court in relation to the need for urgent interim relief. Sometimes they reserve that right to a particular party, maybe the lenders. Now, you could look at those types of situations where the need for urgent relief might arise in the course of a construction contract. My third example would be the enforcement of performance bonds, a lot of which you also see in construction contracts. And typically, those performance bonds tend to be autonomous obligations. In other words, irrespective of what the underlying dispute is between employer and contractor, once the occasion to enforce a performance bond arises, the third party, the guarantor, the person providing the bond, must pay. So there's very little scope for dispute. And those are situations where you find recourse to court or summary judgment again being typically resorted to because there really isn't any defense. If it's an autonomous guarantee or an autonomous performance bond, the guarantor must pay. So I think one lesson for me is when drafting the contract clause, it's important to bear in mind that there are instances where litigation actually provides some value over and above arbitration.
Francis, just to pick up on something that Tunde mentioned, for example, in the instance where an invoice has been raised and there's no dispute on that, and so that it becomes, deemed, and therefore payment is due, and you go to court. One of the ways, for example, in which we have dealt with it in Ghana is to treat that as something that does not come under the arbitration agreement because there's no dispute. So, for example, where the invoice has been raised, you don't raise any questions, and therefore it's accepted that payment is due and the payment is not made. You are able to go to court and say that, yes, I am enforcing, I am trying to get payment, and if the other party comes to say that, well, there's an arbitration clause, the simple answer has been that the arbitration clause is for when there is a dispute, and that dispute needs to be resolved. In this instance, there's no dispute. Payment, the invoice has been deemed accepted and payment is required. So that is one way in which we have dealt with it. And I just want to reiterate what Tunde said, that that's a very important role that litigation plays in the construction field.
Absolutely, I agree with both yourself and Tunde on this key point, and it does go back to the drafting of the contract, whereby some of these sort of vital points can be considered in advance and incorporated into the contract right at the very beginning. Because Nanya, with your way of handling this, it's still required having to sort of negotiate with the other party, right? It's not a straightforward thing. You would still need their agreement to go down that route, that undisputed route, right? In terms of getting the invoice settled. So, yeah.
In that scenario, for example, where a number of days have been given for you to dispute the invoice, and once you don't dispute it, that invoice is deemed as agreed, then which means that there's no dispute in terms of the viability of that invoice and the fact that you have to pay the invoice. The only reason why you go to court to try and get payments and they would come in is because they are not ready to pay. It's not because they actually dispute the fact that they owe the money. It's simply because they don't want to pay and they want to delay it further, send it to arbitration, knowing that there aren't really any summary proceedings. So by the time you go through the whole arbitration process, perhaps they would have the money by then to pay. But how litigation assists in that is that once there is no dispute, which means the arbitration clause has not been triggered, and it's simply an enforcement of a right that has not been disputed, then the courts can come in and give you that summary relief, rather than for you to go to arbitration, waste time and cost to get to the inevitable, which is the fact that the payment was not opposed and it's deemed as due.
Yeah, if I might add, Nania, that's exactly, in actual fact, the point you made, Nania, was the basis upon which we successfully resisted the argument that the matter should go to arbitration. That was before the Federal High Court in Nigeria. But I think the English courts tend to be very conservative about this issue. And there's been a decision, I think, in the course of the last 1 decade. Unfortunately, the name escapes me now. But there's been a decision of the English court where, surprisingly to me, there was a very, very conservative attitude taken to the question of what's a dispute. I think in that particular case, the word dispute was defined in such a way as to mean that so long as your respondent is not accepting your claim, then there's a dispute and it has to go to arbitration. Unfortunately, in arbitration, you don't have summary judgment procedures. I thought that was quite an unfortunate outcome. And so, yeah, I mean, I hope African courts, continue, the trend of the point you just now, which is if it's a deemed approved invoice, then there is no dispute, no matter what the respondent might say at the point you want to enforce the invoice.
Yeah, indeed, there's a risk. There's a risk that even though it's a deemed, invoice or what have you, that I mean, it's very nice that Mr. Pabolo had, a claimant or a respondent who sort of considered that, the matter can be decided by litigation because, one possible argument, which is, as he had referred to, that's how the English courts have treated is to say, well, a party, even if, the invoice is very clear, there's no defense to the invoice and what have you, a party who refuses, by the virtue of a party refusing to pay that invoice, inherent in that refusal is a dispute. So in which case, a respondent, if you then go to court, a respondent to that action, can say that, well, there's an arbitration agreement, and to the extent that, the other party who is supposed to pay the invoice is not paying the invoice, then there's a dispute. By not paying, there's a dispute. So that's question of non-payment should be determined by arbitration. But I mean, it depends on the courts. Some courts would say, well, it's very clear there's no dispute. Let's go the summary judgment routes. But if you have a very creative respondent to that case, the respondent could also insist that there's an arbitration process that should be respected. So I just thought to should draw some sort of very fine distinction that it's possible even in that scenario for a respondent to challenge such claim on the basis that there's an arbitration provision.
Thank you, Adiola. That's a very useful point there. But this discussion takes us straight into the issue of arbitration and the risks that come with that. Because although it's widely sort of noted that, yes, arbitration is the preferred method of dispute resolution in terms of the construction industry, it does come with risks and it does come with gaps that we've just straight off in this discussion picked up on in relation to this deemed approval issue, and whether litigation is a better option in some matters other than arbitration, even though arbitration may be the main sort of agreed route. So it would be good to hear from you, Tunde, on the risks of arbitration in its application in the construction industry in West Africa. starting with your experience in Nigeria?
Thanks, Francis. There are two risks that I would identify. The first is the risk that your expectations may turn out not to be fulfilled in terms of your choice of a seat. And that's because I know in many construction contracts, when negotiating those clauses, parties give very careful thought to the seat of arbitration that they choose. And sometimes the choice of seat is driven by so many factors, among other things, the importance of neutrality. So you don't want, particularly for instance, your contracting counterparty is a government entity, then you don't want your arbitration to be seated in the host country. That's the country in which the project is being implemented, because the cost of the country might feel a certain deference to the government entity that's your contracting counterparty. So it would not be very often that a contractor would be happy to accept the seat of arbitration to be that of the host country in which the project is being implemented, particularly when you have a government counterparty. But unfortunately, in my experience, you know, your choice of seats, the care with which you have chosen, number one, arbitration as a mechanism, and the care with which you've chosen a seat might be frustrated, because depending on whether the courts of the host country show sufficient deference to arbitration as a mechanism and are ready at all times to enforce the arbitration agreement and tell parties to go to the seats that they have agreed, to go to the mechanism that they have agreed. In the course of the last couple of years, I've dealt with no fewer than 3 or 4 cases where parties have obtained injunctions from courts to restrain arbitrations taking place abroad, where the choice of seat was a foreign country. So you can never completely discount the significance of the courts of the seat, of the courts of the host country, that's a project country, simply because you've chosen the seat of another country. So that's one way in which expectations may be defeated, and that's one significant risk with dispute resolution in the context of projects located in certain African countries. Another risk, of course, that you have to bear in mind, and this is one that can very easily be managed by contracting or by the manner in which you implement your arbitration agreement, is the risk that there is some degree of finality to arbitrators' decisions. So unlike in court where you litigate a dispute, you can have an appeal and probably a further appeal. In arbitration, you cannot. You must accept the arbitrator's decisions. There are just very limited circumstances in which you can challenge arbitrators' decisions. In Nigeria, for instance, you have to show that the award was outside the scope of what was submitted, or otherwise there was no jurisdiction, or you have to show that the arbitrators misconducted themselves. And misconduct is a very technical term of art that connotes a very, very limited set of circumstances in which you can challenge an award. Certainly, there is no room for a full merit review. And what does that speak to? It speaks to the need to be obviously very careful when you choose your arbitrators. You have to choose arbitrators who are very, very familiar with process, who know the arbitral process very well, and who also understand the sector, the sector in which you are likely to have a dispute, which in this case will be the construction sector. So those are the 2 risks I would identify. The second one can be handled by being careful when you choose your arbitrators. I suspect that the first one, about managing expectations when it comes to your expectation that the other side will respect the arbitration clause. Perhaps, and I've had cause to mention this in a different forum, time for negotiators to again begin to think of ways in which the kinds of clauses you can build into a contract that would ensure that your contracting counterparty will respect the arbitration clause. I have suggested, for instance, in the past, although it's something I continue to give more thought to, if it is possible to take out a performance bond for performance of substantive obligations, then why should it not also be possible to financially guarantee respect for the dispute clause? Now, it's a point that operators in the industry may want to talk about and debate about. I can easily see arguments for and against that proposition, but I think the time has come for negotiators to begin to think of in what innovative ways can we ensure that contracting counterparties will respect the arbitration clause.
Thank you, Tunde. I totally agree with the risks that you've pointed out. And these are very sort of salient points, and they have occurred in relevant cases. There is a recent case, it was an East African case where the award was not enforceable because of the governing law choice. The national courts would not go with the other parties' attempt to enforce the award based on the fact that the governing law had been changed from the actual contract, and there were issues around that. So governing law is such a major point with arbitration. It would be good to hear from Nanya, please, on your thoughts on the risks associated with arbitration from the Ghana perspective.
I'll have to re-echo the point that Tunde made about the choice of arbitrator. Because arbitration is binding, it's important to have a good mix of legal knowledge as well as technical knowledge. Now, a lot of times people choose arbitrators based on the legal knowledge and their knowledge of the procedure, forgetting about the technical requirements to be able to effectively deal with the dispute. And therefore, one of the things that, you know, as a point you call, one of the things that you have to do when you have, for example, the choice of choosing 3 arbitrators would be to have a good mix of arbitrators with the legal knowledge or arbitral proceeding knowledge and arbitrators who have the technical knowledge for the particular kind of dispute. In relation to the seat, I think 4 points can be mentioned. Tunde has already mentioned one, which has to do with the interventionist nature of the court. I have also experienced a case where there's a foreign seated arbitration, and arbitration has commenced, but a court in Ghana then issues an anti-arbitration injunction against the arbitral tribunal, arbitration proceedings in The Hague. Of course, in that situation, the arbitral tribunal did not give any heed to the supposed anti-arbitration injunction that had been issued against the parties. But it goes to show how important the courts on the ground or the courts at the seat where you have chosen the arbitration to be based is important. Another point that needs, another risk associated with the seat is the willingness of the courts at the seat to support arbitration proceedings, especially by issuing interim measures. So, for example, under the English Arbitration Act, it specifically provides that the English courts can issue interim measures or, can assist with interim applications in relation to foreign seated arbitration proceedings. Under the Ghanaian Alternative Dispute Resolution Act, it mentions interim measures in support of arbitral proceedings seated in Ghana. It is silent on the status of foreign arbitral proceedings. So you then have a case where, I mean, personally, I think that there are strong arguments to be made in favor of the Ghanaian courts being able to support a foreign seated arbitration. But the truth is that it's not very clear, and we don't have direct case law on that. So you might end up having a risk of, having your arbitration in another country, and then the courts that can provide the necessary support for the arbitration may not be willing or may not be in the position to offer that support. Another important thing that comes to mind when we are talking about risk is understanding the regime at the seat of the arbitration for setting aside the arbitral award. And for this, I'll give a practical example. Some years ago, about 4 years ago, we were instructed in a matter where an investor party was seeking to enforce an award, an arbitration award in Ghana. The arbitration was seated in another jurisdiction, and they wanted to enforce it in Ghana because it was a company. Now, we needed to resist enforcement, and one of the grounds that would allow us to resist enforcement is if the arbitration award has been set aside at the seat of the arbitration. So our advice was that in any event, there were so many errors that had been made by the arbitrator who sat on the case, because the arbitrator was sitting on a similar case involving the same parties and somehow had conflated the facts of the two cases. And so the award that he had issued had some of the facts in the other arbitration, included in the arbitration award that he was given, and based on those facts made certain findings. So there was sufficient grounds to have those to have that award set aside. They applied to the court at the seat to have it set aside, but they did not realize an important provision at the court of the seat, which was that you can only apply to set aside an arbitration award where the other party has applied to have the award authenticated or confirmed to be able to enforce it at the seat. So if the party if the award is not being enforced at the seat of the arbitration, there's no opportunity for you then to ask for the award to be set aside at the seat. Unfortunately for our clients, the other party was not seeking to enforce the award at the seat at all. They were seeking to enforce the award in Ghana, where obviously the assets of the Ghanaian company were, and therefore they were in a strange position where there were grounds to set aside, but a statutory precondition allowing them to bring that application had not happened. And at first instance, they were refused. At the Court of Appeal, the court said, yes, we will set it aside. But then there was another appeal to the equivalent of the Supreme Court in that jurisdiction. And it was held that statutory precondition had not happened, and therefore the application to set aside cannot be heard. So that's an important risk. Sometimes when we are choosing the seat of the arbitration, we don't pay too much attention to the laws and the procedural rules of that seat, and you might find yourself in a conundrum where you have an arbitration award that you need to set aside at the seat, and for one reason or the other, you are unable to do that. I think the last thing that comes to mind is the general attitude of the courts when it comes to enforcement involving a state party. Now, you have construction contracts where the other party, you are building or constructing something for a state entity, and you need to consider when you are choosing the seat whether the seat how amenable the seat is to enforcement against state parties. Now, we have had the situation where we've been instructed to represent clients, and we've had to advise that perhaps it would be better, even though most of the assets are in Ghana, it may be better to consider enforcement in other jurisdictions where there may be bank accounts or other assets, because of concerns about whether the arbitration award, because of the particular party, the state involved, and because of public policy considerations, it may not be enforced. So I think that certainly is a risk that parties need to consider when they are choosing the seat of arbitration, or they are considering arbitration as the preferred dispute resolution mechanism.
Thank you, Nanya. That case you highlighted really strongly shows that one of the major risks in terms of arbitration clearly has to do with the enforcement of it. And enforcement tied to the governing the seat of arbitration is something that has clearly come through in our discussions. So it segues us very neatly into our sort of final topic, looking at the time, which is to do with enforcement, difficulties with enforcement and its application in your experiences respectively. So I will go to Adiola to speak on your your experiences on the difficulties of enforcement and or the issues to do with arbitral enforcement actions.
Thank you, Yvonne. I just wanted to quickly make a point on the seat issue, because I think it's very important and is a recurring one. So just like Nanya and Mr. Pabo said, of course, the parties have to be very mindful, of the seat and, be very mindful of the court's attitude to the enforcement of awards or setting aside of awards. But you find out that even in situations where the courts, for instance, in Nigeria, I find that the courts, at least in my experience, typically defer to the arbitrators. I mean, have been parties, whether for the applicants, but most of the time for the respondents, in a setting aside application. And what the courts will typically do is to just hands off and say, well, you choose your arbitrators, except there's been something really wrong with the award. We're just going to leave the award as it is. In the Econet wireless case, for instance, both the High Court and the Court of Appeal refused to, to interfere with the award. Even in the recent there's a recent Supreme Court decision that was delivered, I think 2019, the Mekuyes case, even though the Court of Appeal had tried to interfere with the arbitrators, the Court of Appeal had tried to set aside the award. Eventually, when the case got to the Supreme Court, the Supreme Court practically just looked at the reasons and found that they were very flimsy. I mean, they were very flimsy in that particular case, because the applicant had sought to set aside the award on the basis that, the arbitrator misconducted herself because she wrote a letter on her office letter head instead of her own personal letter head, that the appointing authority mentioned in the contract said Chartered Institute of Arbitrators, London, whereas there's something like Chartered Institute of Arbitrators, London, Nigeria branch, whereas there's something like Chartered Institute of Arbitrators, London, Nigerian branch. What you have is Chartered Institute of Arbitrators, United Kingdom, Nigerian branch. And then the third one had to do with the appointing authority using the words recommendation instead recommending, in appointing the arbitrator, using the words we recommend the arbitrator instead of we appoint the arbitrator. I mean, they were very flimsy grounds, and for some reason the Court of Appeal upheld those grounds. But of course, when the matter got to the Supreme Court, looked at those grounds and said they were very flimsy. And again, we stated, the point that you really can't interfere with, an arbitral award except on unlimited grants, which are provided for in the Arbitration and Conciliation Act. So in Nigeria, you have, courts, and from my experience, really deferring, to arbitrators. But despite that, you find out that parties, whether it's a lack of knowledge or just because in Nigeria, it's very easy to go to courts, they're hiring a lot of this incentive, preventing parties from going to court. You realize that even with, the seats being very supportive, parties still tend to, go to try their luck in court and still try to set aside an award. One particular provision that I think is very helpful, I'm not sure people realize that, is that if you have an award, you can seek to enforce the award, especially if it's an international award. especially if it's an award from an international arbitration. The Arbitration and Conciliation Act, allows you to bring an application to enforce that award. And if the other party, despite the fact that Nigeria has, a very deference approach, when it comes to interference with an arbitrator's award, if the other party insists, and decides that they're going to set aside the award, there's a very fine provision in the Arbitration and Conciliation Act that says when you have an enforcement application and then you have a setting aside application, the courts may defer, may defer the enforcement application, until the setting aside is fully considered, but on a condition, that security for costs be provided. So I think if arbitration practitioners take advantage of this provision, and say to the respondent that if you're going to, despite the fact that that Nigeria has a deference attitude, if you decide that you're going to appeal, go to the High Court, go to the Court of Appeal, go to the Supreme Court, at least put down some sort of whether it's a bank guarantee or whatever, so that at least once the the successful party has an award, there's some sort of guarantee, some sort of security, in relation to that award. So I just want to mention that in terms of seats, yes, seats is very important. Yes, parties will try to maneuver, and then still find a way to elongate the issue. But then again, it's also very important for arbitration practitioners to try and be creative, so that even when you have a seat that is very, very helpful, still find a way, to discourage respondents from appealing or filing frivolous setting aside application. In relation to the question that you had, mentioned in terms of enforcement, and some of the issues, practical issues, that may come up with enforcement. I mean, it's pretty much clear. If it's mediation, half of the time you have a settlement agreement one way or the other, even though with mediation, you can, if a party decides not to comply voluntarily with the settlement agreement, what then happens is that, a fresh action has to be started, suing the party who is in breach of that settlement agreement, as it were. But at least you can go to court directly, right, to sue for breach of a settlement agreement. So that's the remedy. For mediation, there's a settlement agreement. You expect parties to honor the settlement agreement, but when they fail to honor the settlement agreement, then the option open for the other party is to go to court and sue the defaulting party for breach of contract or arbitration, depending on the provision in the settlement agreement. For arbitration, I mean, enforcement is also very straightforward, because in Nigeria, there's a regime for enforcement of arbitration award, whether it's a domestic award, whether it's an award from a domestic arbitration or it's an award from an international arbitration. The mechanisms in the Arbitration and Conciliation Act that allows for enforcement. But where you typically then have a bit of challenge is when it's adjudication. And like I had earlier said, when we were talking about the popular means of ADR mechanisms, in my experience, I've seen that especially with FIDIC contracts that are based on FIDIC usually have adjudication. But in Nigeria, you don't have a regime for enforcement of adjudication. So the problem with that is, if you then have an adjudication decision, how do you enforce it? Because there's no statutory regime for enforcement. What the parties have to do is to look at the contracts. Typically, what FIDIC contracts would typically provide for is that in the event of non-voluntary compliance with the DAG decision, a party has a right to start another arbitration proceedings, right? To enforce, the non-compliance, which I mean, can be straightforward, which can be problematic, because whereas with an arbitration award, the moment you have an arbitration award, if a party decides not to comply with the arbitration award, then under the Arbitration and Conciliation Act, the winning party has the opportunity to go to court and seek enforcement. But if it's a FIDIC contract and you have adjudication and you have an adjudication decision and a party decides not to comply with the adjudication decision, what you usually have in the FIDIC contract is that the non-compliance should be referred to arbitration, which then creates a problem, because one, you can't go to court straight. The other thing is, if you're going to arbitration, what exactly is the role of the arbitrators? And the arbitrators simply just to rubber stamp the adjudicator's decision, or do they have the right to review, or decide the right to review the decision, or check the underlying dispute and see whether the decision was even right in the first place. So one way to circumvent that, even though in standard FIDIC contracts, what you will have is, when there is a non-compliance, the question of the non-compliance should be submitted to arbitration. But because of the facts, because of the issues surrounding the uncertainty surrounding the question of, if you go to arbitration, what powers does the arbitrator have? Does the arbitrator have power to open and all of that? I think it's very important for parties who have FIDIC contracts to be mindful of that. And most of the standard contracts can be amended in any event, to amend that particular provision to say that, whereas, of course, the adjudication decision should be binding, but in the event that a party decides not to comply with that decision, then the other party should have the right to go to court, because if you have that, then it means that the party can just simply go straight to court and doesn't need to go to arbitration first. And a very good analogy for that is with expert determination. For expert determination, which is also a contractual mechanism, sometimes the party pre-agree in the agreement that in the event of, even though the expert determination will be binding, in the event of non-compliance, an aggrieved party can either go to arbitration or go to litigation. So in the FIDIC contract context and in the context of adjudication, my advice would be, even though the FIDIC contract typically would ask that a party submits non-compliance to arbitration, to prevent the issues that may arise, where the parties have to, go to arbitration again. It will be very helpful for parties to pre-agree that in the event of non-compliance, a party can go straight to court, so that it makes it easier for them and, can take away the risk that comes with having to go to arbitration, and then all the uncertainty that comes with what the arbitrator's powers are for hirings.
Thank you, Adela. Thank you for your comprehensive review of the position on the Nigerian perspective. Tunde, it'll be good to hear your sort of final thoughts on this issue in terms of enforcement. And if possible, it would be good for us to look at whether in all of this, whether adjudication could also be a way forward for the construction industry in terms of its inclusion in the dispute resolution process.
Yeah, Francis, thanks. I think Adela said it all as far as Nigeria is concerned. I mean, the caveat that I would put there is that, unfortunately, I don't share upbeat attitude when it comes to the way Nigerian courts have dealt with arbitration matters. I do agree that perhaps if one were to do an empirical analysis of it, one would find that most judges defer to arbitration agreements and arbitration awards. But I think that I've also seen quite a number of very egregious departures from what one would expect. Take, for instance, a judge who says, who sets aside an award on the basis that the arbitrator did not recuse himself the moment he was challenged, when the rules of the institution, the ICC, actually reserve to the ICC court the right to decide whether a challenge is correct or not, right? And we've seen such similar, egregious departures from the fundamental principles of how you approach an arbitral award. So, I mean, my concern is that we are not yet at that place where it is certain that a judge would respect an award the way the law requires that it should be. Whereas we have that certainty, because it's that very certainty that would discourage frivolous applications to set aside award. But for as long as people think that they can play the system, they will. And for as long as judges give judgments that you find questionable when it comes to challenges to arbitral awards, then people will think they can play the system. And Nigeria will not be a very good seat for enforcement efforts. So I would add that caveat to what Adeola said. I think we have a lot more work to do in terms of sensitizing our judges to understand the policies that underpin arbitral awards. So that continues to be a risk. The other challenges for enforcement that I would mention would be very practical ones, like availability of public information on assets to aid assets investigations. Because if you are going to enforce against assets, you should be able to have very easy access to information about where the assets are and what the assets are. Those tend to be challenges in terms of enforcement. The third risk, the third challenge with enforcement that I would identify is the efficiency of the judicial process. If you have to spend 15 years determining whether you can enforce or not, because you have a three-tiered judicial process that runs from the High Court up to the Court of Appeal and up to the Supreme Court, and unfortunately, arbitration enforcement applications have to take their turn on a very long queue over such a very long period of time, then again, your country will not be a very attractive seat for enforcement efforts. At the end of the day, of course, enforcement follows the money. It's where the assets are. And if assets happen to be in Nigeria, then you have to come to Nigeria. But we also have to make it a lot easier for people who seek to enforce in Nigeria to achieve that objective. And so while I think Nigerian courts are doing the best they can, I don't think that best is good enough. I think they need to be a lot better than they are doing right now. I'm not sure about other African countries. I think we need to have a process of actually doing an empirical study of how African countries perform when it comes to enforcement of awards, and indeed enforcement of arbitration agreements as well. I'm not one to whitewash or to market African countries. We need to know what the truth is, and we need to work on it to make African countries attractive. So that's my position on that. On adjudication, I think my experience, well, I don't have much experience in adjudication, but my understanding is that typically you have recourse to that process because you need some kind of interim decision that is reviewable through a more detailed process like arbitration or litigation, but you need an interim decision that the parties will respect. And if they don't respect it, then there's a very summary way of ensuring that they respect. I think to a large extent, industry itself plays a great role in ensuring that adjudicators' decisions are respected. So for instance, if there's a name and shame kind of facility within a particular industry sector, if you are known to be a contractor or an employer who does not respect adjudicators' interim decisions, then that should affect the extent to which you will be able to contract for work in future and to be able to win bids for projects. If industry is able to put that kind of process in place, then it may be that would see adjudicators' decisions being respected. I think from what I learned from the industry grapevine that typically, because what gets out about the reputation of a particular company, companies tend to respect adjudicators' decisions. I've not seen too many adjudicators' decisions being challenged in court. I've not seen too many of that. That may be because there has not been so many adjudications in the first place, or it may be because people typically tend to respect adjudicators' decisions because of the reputational harm that might come if they did not do so. But I mean, I will obviously defer to Nania and Adiola on this because I think they have more experience on adjudication than I do.
Thank you, Tunde. I agree with you as well, in addition to all the panelists, but the point about the empirical study being needed to be conducted on the West African position is key. There's quite a lot of information that has been set out on the East African experience in terms of the enforcement of arbitral awards in East Africa. But there needs to be more done for West Africa, and it probably needs to be then a condensed position in terms of the African experience. And in terms of the enforcement of an adjudicator's decision, or the role that adjudication plays in this sector, we have seen that within the West African experience, it's not being utilized at all. But interestingly, there's a case, an East African case, or actually a South African case called Ukuleni West College versus Seagull, and that was a 2020 case. And that was a case in which they sought to challenge the decision of an adjudicator. It was a multi-tiered contract, multi-level contract, and the parties sought to challenge the determination of the adjudicator in a case where provision had been made for a matter to go to arbitration as well. So they had adjudication and then they had arbitration. And once they had the adjudicator's determination, they sought to sort of set that aside. But the court refused to do that on the basis that the adjudicator's determination stood. So that would be interesting to see, how that would translate within the West African experience, if it did come to that, whereby we start to see more sort of adjudication involved or included in the construction industry position. But that would be my feedback to your point on this. And I throw it back out to Nania for her final points. We're coming close to the end with just 1 minute to go for closing remarks. Just your thoughts very quickly on the way forward in terms of the construction industry for West Africa.
I definitely think that there's a lot of room for arbitration to grow, for adjudication to grow. And looking at what has happened in England and Wales, there's a clear path towards adjudication because it provides, number one, a quick interim remedy that within that time it's somewhat binding on the parties, and the project is able to move forward within that period and not be stultified. So I definitely think it's something that is going to continue to grow. And as the industry becomes more complex, adjudication is definitely going to be the way to go.
Thank you. So thank you everyone for your incredibly insightful comments, feedback, and experiences in this vital sector. Really appreciate the time that's been given to this, and I thank all the organizers, Herbert Smith and the law firms that are all party to this, for this opportunity to really focus on a very important aspect of our industry. Okay, so wishing you a very good evening, and thank you again.
Thank you, everyone.
All right, bye everyone.